We do have some email questions coming in, and I know that you're here to offer the good expertise that you offer. So let's get to Debbie's question. And her question has to do with what happens when you get hurt on the job. That's what happens to her husband. Her husband's hand was almost severed when the guard on a power saw he was using snapped off. He had some serious injuries to his hand, his wrist, and his forearm. And the manager of the store that he brought the saw from said that they needed to contact the manufacturer. Her question is, should she call you? Should she get a lawyer before she does that? What should a person do?
That's about a three-part question, but taking them in reverse order, yes, she should get a lawyer. That's true. If it was in Georgia, the owner of the retail establishment where they bought the saw probably is right. It would go back to the manufacturer and not the vendor. Is that correct, BJ?
Well, you can have some warranty claims, not defective product claims.
Yeah, have there been some changes in that? And if he was on the job, as to his employer, his total recovery would be within the realm of the workers' comp claim. Now, as to the product, that's a whole different story. I don't know what the specific malfunction was. Did you get that?
I said a guard failed on a power saw. So
yeah,
it was either it was inadequate or not put together appropriately, I would guess.
Yeah, and it could have been on a failure to warn. You mentioned that earlier, BJ, and I was going to raise a point about that. I think there was a statute passed not too long ago that in Georgia as to product defects, wasn't there like a 10-year statute proposed?
Yeah, there is. As to Georgia has a strict product liability statute, so you have to prove defective product and there's strict liability. That only lasts for 10 years from the date of manufacture.
But the escape clause is you can go to the failure to warn,
right?
Even if it's more than 10 years old.